You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. Welcome, Bill.
Good day.
So I guess today is the tabloid edition of our show. Our top story centers on the infamous Versace Mansion in South Beach, Miami, where famous designer Gianni Versace, of course, was shot to death on his doorstep back in 1997. I understand the property is up for sale. When does it come up for auction?
The 19th of September, under the auspices of the U.S. Bankruptcy Court in Miami. This is a really rather nice piece of property, by the way. It is on the main drag in South Beach on Miami Beach. It is a marvelous building that is supposed to look like Christopher Columbus's home in Genoa, Italy.
And how did it get tied up in a bankruptcy case? What filed here?
Well, you know, some buildings are just star-crossed, and this is one of them. It was tied up, and still is tied up, in the Scott Rothstein Ponzi scheme. He used some of his stolen money to buy a piece of the building. It lost its tenant. It is now in bankruptcy, and the secured lender, owed $31.5 million, is seeing to it that this thing is sold double quick. And by the way, I don't think you could buy it for pocket change, because the rules of sale are going to require that anybody who wants to bid has to have the capacity to pay up to $50 million.
We also have news on the Casey Anthony bankruptcy. She, of course, is the young woman who filed bankruptcy after being acquitted for murdering her 2-year-old daughter. What developments do you have in this case?
Well, I'm very disappointed. I was hoping to be able to report multiple times on a fascinating legal issue. The bankruptcy trustee had received an offer to sell her life story. And as you can imagine, she objected, saying that there is no property interest here that properly can be sold. This was an enormously unique and very interesting issue of bankruptcy law in terms of what is property of the bankrupt estate. In any event, the bankruptcy trustee has decided to settle. Ms. Anthony is going to pay $25,000, question where did she get the money, to in effect buy back her life story. This will not be a sale. It is being structured as a settlement so that theoretically, at least, competing offers are not possible.
That is probably one of the wackiest developments in all of bankruptcy law we've probably talked about on this show in a while. That is just astounding. What a development.
This is bankruptcy, Lee. You know, hang out at the bankruptcy court, and pretty much any day you're going to find something interesting happening. By the way, the trustee told me he understands that a friend is going to loan her or give her the $25,000. My instinct tells me maybe, Lee, we haven't reported the last development.
Yeah, I have a feeling we're going to be revisiting this down the road. Right. We also have a Judge of the Week, and this week it's Bruce Markell from Las Vegas, of course. What did Judge Markell do to distinguish himself this time around?
Well, he is leaving the bench, sad to say. That may make some people in Las Vegas happy, because Mr. Markell, on more than a few occasions, has held people in contempt. But I got to tell you one thing, Lee. For my money, he is perhaps the single smartest bankruptcy judge on the bench today. He is, however, not leaving the bankruptcy business altogether. He is going to become a professor of law, the Jeffrey Stoops Professor of Law, to be precise, at Florida State University. In a way, I think this is all well and good, because Bruce Markell writes opinions as a judge that really read like law review articles, and now he will be better able to write law review articles and, I think, actually say what his opinions are on a lot of very important topics. And by the way, for his swan song, Judge Markell wrote an opinion which is extremely important, and anybody in bankruptcy land out there ought to read it. It's a case handed down in the last week called Hasse versus Rainsden, and what it has to say is the actions that would be necessary before somebody waives a right to object under the Stern versus Marshall doctrine. If you don't know what Stern versus Marshall is all about, I'm not going to take the time to explain it now, because it wouldn't matter to you anyway. But nonetheless, his opinion in that Hasse case is the leading piece so far about what a valid waiver is of Stern rights. It is must reading.
And Bill, Oreck, the vacuum cleaner maker, went up for auction this week. Who won the sale?
Well, I'm sad to say it looks to me like the employees lost the sale. The bidder going in was the Oreck family, which had sold the business about 10 years ago in a $270 million transaction. They were offering to come back in and buy the business for, I think, about $21.5 million. However, they were outbid at auction. The company that bought the business, or will soon buy the business, is Hong Kong-based Tektronic Industries, which is the owner of the Hoover and Dirt Devil vacuum cleaner lines. So one has to be concerned now for the employees who work in the manufacturing plants, because this could be a product that is now going to be made overseas.
And finally, we have some advance sheets. And Bill, I'm a little bit confused because it says here we're going to be talking about a case or a decision that hasn't quite been written yet. What is the issue that's so important that we're going to discuss it before the opinion finally comes down?
Gifts. Gifts. Not the kind of gifts that you and I ordinarily think about, where out of love and affection I give something to my best friend, wife, girlfriend, or children. What we're talking about is gifts in the bankruptcy sense. Here is how it arose in the life care case where this issue is up for appeal. The business was being sold to secured creditors almost entirely in exchange for debt, leaving nothing for unsecured creditors. The unsecured creditors threatened all manner of lawsuits, and there was a settlement, and this happens, Lee, all the time in bankruptcy court. The lenders decided to make a gift of $3.5 million to unsecured creditors to be placed in a trust only for unsecured creditors. Guess whose ox was gored? None other than the Internal Revenue Service, who has a priority tax claim for $24 million. They cried foul to the bankruptcy judge and said, you cannot bypass the priority system in bankruptcy by giving this $3.5 million to unsecured creditors where our priority claim for taxes comes ahead of them. Well, of course, this is bankruptcy court, and you guessed it, the IRS lost. They didn't take it lying down. They are appealing this case to District Judge Sue Robinson in Delaware. From there, I suspect whoever wins or loses is going to take the case to the Third Circuit Court of Appeals in Philadelphia, and doubtless about 2 years or so from now, we will be reporting on the eventual outcome of this case, absent settlement. This is a technique, Lee, about making gifts to unsecured creditors to bypass the priority system, which, to the thinking of some, is a flawed theory. The reason I think it may be flawed and may ultimately be set aside and barred in future cases is because creditors' committees, when they wrangle these settlements, are typically threatening to make claims that belong to the bankrupt estate. So, if they get a proceed based upon a settlement of a claim that belongs to the bankrupt estate, seems to me that that money ought to go to the estate, not to the creditors. And I'm going to tell you something else, Lee. If this happens, and if these gift theories no longer work, there are going to be a lot of bankruptcy cases, Chapter 11 cases, where unsecured creditors get nothing. This, I think, will not be the end of the story, because I think at that point, we're then going to have a bigger push to do something about bankruptcy sales where the secured creditors run away with everything only in exchange for debt, in effect bypassing the more cumbersome state foreclosure system.
Wild stuff. Bill, thanks for that.
You're welcome.
That's Bloomberg News Bankruptcy Columns with Bill Rochelle. Be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. Also, be sure to check out our videos on YouTube and follow our updates on Twitter. I'm Pacchia. Thanks for watching, and see you next week.